And we are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host. And today we're going to talk about, first topic is the LBRY case. A lot of people think that the LBRY case is over and that LBRY is dead and gone and that they've been successfully killed by the SEC in the name of protection, which we're going to talk about, but that's not the truth. What happened is the LBRY is appealing the decision by the judge granting summary judgment to the SEC. Now, for people, let's sort of do a quick recap of what exactly transpired. The SEC, after investigating this small little startup in New Hampshire called LBRY, that did not hold an ICO, but they had some LBRY credits in a blockchain technology that is meant to provide an alternative to the YouTubes of the world. You know, certain technologies that censor us and that really don't adhere to free speech sometimes. Well, we want an alternative to that. And we have it in this blockchain technology under the LBRY system or platform. And so the SEC, however, said, well, wait a minute, you made a sell and we're gonna investigate you. And they investigate Jeremy Kauffman, the CEO, and LBRY for over 3 years. And check this out. It cost between $1 and $4 million in legal fees because depositions are going on, forensic accounting, expert fees, all kinds of money are being spent. LBRY went in there and they had a PowerPoint presentation to say, look, everything that Bill Hinman said applies to us. This concept called sufficiently decentralized, decentralization, we meet that. We are as sufficiently decentralized as Ethereum, and you all blessed Ethereum. So clearly we're in the mix, and we didn't hold an ICO like ETH did. You don't have to give a speech and say, setting aside the fundraising, right? We went through venture capitalists. We do hold some tokens, and the SEC investigated them for years. And then, of course, files a lawsuit seeking $22 million from this small startup. And they sued in 2022. It was after the Ripple case. Instead of the Second Circuit, it's in the First Circuit. And remember, I'm telling you that they're filing these cases in multiple circuits because they want to come after crypto and they want multiple jurisdictions and they want multiple precedents. And so that's what happened. And I believe it was November, the judge in New Hampshire, and also just remember, LBRY unfortunately did not contest the first two prongs of the Howey test. Investments, right? Even though there was non-investment use by many, many people, such as Naomi Brockwell, my client, but they just tried to concise it to that third prong. The second prong wasn't contested either, unfortunately. So the judge made this decision, and he came down and he said basically that because LBRY held some of the LBC tokens, and then they did sell to like a Flipside Crypto, which was an investment club, that technically met the Howey standard, and also case law from the First Circuit, which is slightly different than the Second Circuit in the Ripple case. And therefore, LBRY violated the law and LBC unregistered securities. Very vague. And then what happened is they proposed an injunction, and an injunction that said everyone that is involved in the LBRY, with LBRY, in common with LBRY, is enjoined from trading or selling LBCs. Well, that's when, with thank God for Naomi Brockwell's permission, granted me permission. She said, yes, John, on my behalf, you can go in there and fight. And on January 30th, I went into the hearing as amicus counsel and said, look, Judge, whatever. We're not here to argue about LBRY, but the secondary market sells, people like Naomi Brockwell, who's never sold an LBC, who's never purchased an LBC, but owns LBC and uses it in her platform to get views on her content. That's clearly not a security. We'll all agree to that. So your decision, could you please clarify that it does not apply to secondary market sales? And on the record, the judge agreed with me, promised me, assured me that he was going to make sure that the world knew that his decision did not apply to secondary market transactions. And that was a very important point because Judge Torres in the Ripple case cites that hearing and cites that dialogue between the judge and myself, where the judge says, I will make it clear that secondary market sales are not impacted by my ruling. It is limited to LBRY direct sales. Very important. The judge cited that in justifying, or not justifying, but in as another example of why her decision makes sense. And it does. Now, the reality is the judge went back and he got cold feet or whatever he got, and he didn't fulfill his promise. He just said he's not going to give an opinion on secondary market sales, but everyone should agree, sort of that token holders like Naomi Brockwell should not be impacted. Bottom line is, I think it was just recently in July, there was a final decision because it went from that decision, it went to the penalty phase. How much should this company pay for this unregistered offering of securities that the SEC feels so strong about that we got to go into New Hampshire and shut them down? $111,000. $111,000. That's what LBRY has to pay. So please just think about this for a moment. Jeremy Kauffman and LBRY spend between $1 and $4 million in the investigation phase. Then they get sued and they spend another couple $1 million in legal fees. The SEC spends ungodly amount of hours, taxpayer money. And when it's all said and done, the government protected us by getting $111,000 from LBRY. They said that they were going to forget disgorgement and that $22 million figure that they threw out there out of thin air, almost like a pre-mine, man. It just came from nowhere, right? And said, boom, we're just going to ask for 22 million. Nope. They said, okay, well, we've successfully destroyed them financially. We did what we told Jeremy Kauffman we were going to do when he argued with us and we said, we will bankrupt you, pal. Well, they cite, well, they're pretty much defunct. They don't have any money because they spent it all on legal fees. So we'll just take $111,000. That is the result in the LBRY case. And you will learn, hell, many of us would have just paid that and said, can we avoid all this nonsense? All right. Many of us fighting behind the scenes have almost paid that. Some of you might learn that soon. But anyways, so that's where we're at. And just recently, the LBRY did not file bankruptcy that I know of. Instead, they filed a notice of appeal. And they're going to pursue and challenge that decision. And I think that they have been emboldened, if you will, because of the grayscale ruling by the Court of Appeals, by the Ripple decision, Judge Torres's decision, by maybe even the Uniswap decision by Judge Falia, and hopefully a really good decision that comes down in the Coinbase motion to dismiss. Why is it important, right? Why is this appeal important? Well, it's important because so far we're winning as we get higher to the courts and it gets more conservative. And eventually the Supreme Court, many of you have heard this doctrine called the major questions doctrine and other things. There is no doubt that the SEC has unconstitutionally tried to expand the Howey test into secondary markets regarding general asset sales that just happen to be cryptocurrency, digital assets. Remember, people, there's not a case in 80 years that supports taking an asset that may have been an investment contract in the beginning and then calling it an investment contract, the underlying asset, forever. There is none case law to support that. And there's not one case law that the SEC can cite when a person does not have any level of privity, right? Business relationship between the person. You just go on exchange and you're buying it from someone you have no idea who they are. There's not a case in the history of the United States that would support that being the sale of an unregistered security. Now, let's think for a moment. Who got protected by this lawsuit by the SEC? Who's protected? Oh, it must be all those crazy LBC traders that we had to stop. Well, it can't be that, because as some of you remember, I spoke with Anthony Scaramucci's professional crypto trader. We were given a speech together, not together, but at the same place. And I spoke to him, nice guy, I think his name's Dave. And when I found out what he did for a living, I was like, hey, I'm going to ask him what he thinks about this LBRY credit, this LBC. And I asked him, I said, Dave, you trade these cryptos, like you know most of them, right? Oh yeah, he knows many of them. What about this LBC token? John, what's that? I go, Dave, you never heard of LBC? He goes, nope. Never heard of LBRY? Nope. A professional trader had no idea. The reality is that LBC token is really, when you think of it, one of the best examples of a utility token where you're using the token to access the platform. It's not this massive speculative token, right? Bitcoin's way more speculative. XRP is more speculative. ETH is more speculative. LBC, come on. So why would the SEC go to such lengths to stop this innovation in its tracks and bankrupt it? So I throw that out there for you. You know, under the law, if we look at things most favorable to this judge in New Hampshire, when LBRY sold LBC to a crypto trader, Flipside Crypto, and they put some tokens in cold storage, could that technically meet the definition or satisfy the Howey test? Sure, it could. But are those the cases we want the SEC pursuing when there's FTX, Celsius, Voyager, the pump and dumps, the memes, people left and right scamming people? That's where we want these limited resources that Gary Gensler talks about before Congress when he begs for more money. You're going to spend your efforts on LBRY. And so many of you know Jeremy Kauffman isn't stopped fighting, right? He had a quote where he's like, they're trying to use this verdict against my small company, not in these words, I'm paraphrasing, but use it as a precedent against all of crypto. And so we're not going to stand it. We're going to not just fold. We're going to fight. That's admirable. And I take my hat out to him. You don't have to like Jeremy's politics or whatever, but you have to love the fight, man. You have to love the fight. And so Naomi Brockwell, God bless her, she'll be in that appellate court as well in briefs. If there's an oral argument, I'll ask to participate. We're not going away. We're going to keep fighting, always keep fighting. All right. Now, that's the LBRY case. What's the second thing I'm going to talk about today? I'm going to talk about this ETH ICO. I put it on the thumbnail, right? Now, there was a little bit of controversy about the announcement, and I'm going to address that for a second. Most of the people, my God, I love you so much. You're the best people in the world. But there were still, just so you know, there's some people that you can never satisfy. I'm not cared about them. There were some people, you know, that were genuinely maybe disappointed. And I understand why, but I want you to think about something for a second. I want you to think about how long we've been fighting. I was called a conspiracy theorist when I brought up Bill Hinman's $15 million. I got attacked. and I got attacked for over a year. People joined me, and we started uncovering things, and the conspiracy theorists kept going. If you go on my library, on my video library on Crypto Law, we had all these videos of a guy named Steve Nayeroff, who was the architect of the ICO, a guy who worked with Joe Grunfest at the very beginning, talking to the SEC, a guy who said that he was the one who came up with crypto fuel and the fact that ETH was being used as a utility token, as fuel among the network, and was therefore not a security. And a guy who was at the beginning, think about the architect of the ICO. And we've been talking about ETHgate and called all kinds of names and conspiracy theorists. I was completely blacklisted by industry. Trust me, I know, because I was attacking, not attacking, but exposing the truth related to some of the most powerful people in crypto. And I want you to think about a year ago, if I told you I formed an attorney-client relationship, privileged communications with that guy. I want you to think about how huge that news would have been. And so it is significant because, and I'll show you how significant it is for the people that were disappointed. But, and I understand why. I got to tell you, I saw one person who never talked to me ever. And he had tweeted out 5 times how massive my announcement was going to be. He's never spoken to me one time. I've never had a conversation with him. And then he said he was disappointed in my announcement. And I'm like, dude, you disappointed yourself from all the hype that you built up. All right. But we've been fighting for so long, and people are so sick and tired and frustrated by all of this. I understand why people are hoping for more, but I want to put you how significant this is. All right. There is an email that just went out, not an email, but a tweet that just went out by Steve Nayeroff. Okay. And I want you to read what it says. All right. Remember that piece of paper that Joe Lubin talked about? And he said, before the ETH ICO, I had a piece of paper in my pocket. Right. Well, there it is. Look at the date, people. Guess who got that piece of paper in Joe Lubin's pocket? That's right. Steve Nayeroff. All right. So that's extremely significant. And I want you to just think about that for a minute. That's extremely significant. And so that's why I was excited about it. And, I apologize if other people kept hyping it up to the point where, short of me announcing that the case was settled or that XRP was going to $2 or something, that it was going to disappoint people. But we are getting closer to the truth. And I think it is significant. And I think it is big news, because at the end of the day, how long has people been fighting for this, right? We just want transparency, and we're getting closer. Okay. Now, but I completely understand it. My God, we shouldn't be in this position. We shouldn't have waited for 3 years. We shouldn't have fought like this. We should have had a level playing field. People behind the doors were cutting deals and screwing people's lives over, screwing people's financial investments over. It is not lost on me how many people's IRAs were locked up and frozen over a damn lawsuit that didn't involve fraud, that didn't involve misrepresentation. So I feel for all those people that are frustrated, and I feel for them, and I will continue to feel for them. Okay. Now, the final thing is, and I'm not going to talk about my book. I'm going to let it speak for itself. I love you out there who are defending me. Just know that I appreciate you so much. So I don't care what people say about me, but when you start talking about people that I care about and insinuating something different, that's an all different ball game. I was excited about my Spin the Bits news. And all I was telling you was that I invested my money, no one else's, John Deaton's money, and that I was investing in Jay and in Spin the Bits. And people were like, oh, Spin the Bits has a coin and Deaton's shilling a coin. There is no coin. I was just excited because I was telling you my news of how excited I was to be a part of this project. Okay. And my positivity got rewarded because yesterday, Jay won for the second year in a row. Spin the Bits won the Ripple CBDC interoperability challenge. Okay. And so, that's the excitement. Anyways, next week, I'm hoping that we can get Steve on. If we can't, be patient. We'll get him on. We'll get to talk to him directly. We're still fighting. I encourage you to listen to Spaces that went down this morning. A lot of people have a personal opinion on that. With that said, for many of you, I will see you on Friday. For those that I won't see on Friday, I'll see you next Tuesday. I love you guys, and I'll talk to you soon.